Good evening, everyone, and welcome to the Brian Crombie Radio Hour on Saga 960. I want to introduce you to Peter Biro. He is at Massey College. He's the Jane Goodall Institute, Newcom optic, a lawyer, an educator, a writer. And I caught him writing a really interesting post recently about combating democratic backsliding. And so I thought we'd reach out to him and find out what democratic backsliding is all about. He's written a book about it, Heroic Citizenship, and he's actually going to be writing a book that's going to be coming out in the next little while about the Notwithstanding Clause, which is also a very interesting topic. Peter Biro, welcome to the show, sir.
Delighted to be with you.
So what is democratic backsliding?
Well, it is the retreat from the practice of liberal constitutional democracy that is more or less defined liberal democracies or liberal democratic political systems in the West, from the post-war, post-Second World War period right up to the present. It is the departure, if you will, from observance of the central norms of liberal democracy, the commitment to the rule of law, the independence of the judiciary and of the prosecutorial branch of government, the separation of powers between executive, legislative, and judicial, and of course a commitment to all of the critical civil liberties that we spend a great deal of time talking about: freedom of expression, freedom of conscience and religion, freedom of mobility and movement, of association, of assembly, and all of the important rights and freedoms that are protected explicitly in many constitutions, including our own, and implicitly in the democratic practices of those countries that don't, for example, like the UK and Israel, for example, and others that don't have a written constitution. But the basic norms are more or less the same. And what I'm focused on is really the movement away, the departure from allegiance or observance of those practices. And we see this throughout the West. And we can talk about specific examples.
Throughout the West? I think we see it
absolutely
in the United States with Donald Trump potentially, but you think it's a more prevalent issue?
Oh, it's absolutely prevalent throughout the West. It exists everywhere because it's not a function, in every case of express, obvious departures from the practices as much as it is an attitudinal shift. It begins with an attitudinal shift. Right now in the United States, it's pretty obvious. You've got at least half the country that is essentially opposed to the Constitution, if you really bring it down. And it's not just in terms of the way in which that population is supporting Trump, for example, but more broadly, many of the gains that were made throughout the 60s, 70s, 80s, the civil rights movement, the feminist movement, the human rights movement broadly, voting rights, etc. There is really a backsliding that's occurring in favor of a variety of other commitments that are, hostile, if you will, hostile to the fundamental precepts of liberal democracy. The place, for example, of religion in the government and politics and civil sort of life of a society that is runs contrary to the principles of pluralism that underpin free and democratic societies. That you've got Donald Trump in the United States who's saying, get rid of the Constitution altogether. Let's politicize the judiciary. Let's make it a branch of the Oval Office's political reach and political jurisdiction. But we see this occurring throughout the West. Let me give you a couple of examples. In Hungary and in Turkey, just as an example, you had Erdogan in Turkey and Orban in Hungary, who actually began political life as liberal reformers and were elected as liberal reformers. It didn't take very long for them to become autocrats. And in fact, the European Parliament recently, in speaking about Orban and complaining about his departure from certain civil libertarian, let's say, prerequisites for membership in the European Union, said that he is no longer even not only is he not a liberal Democrat, he's not even an illiberal Democrat, which is how he's defined himself quite proudly. They're now referring to him as, or referring to Hungary under Orban as a kind of electoral autocracy. And we can talk about what some of the indicia are of that backsliding. All right, some of the indicators and obvious manifestations of it. But it exists in obvious forms there. It exists in Poland with the Law and Justice Party. But it isn't just about the formal changes that occur. I mean, in the case of Hungary, it has manifested in terms of formal changes that are quite dramatic. You don't have an independent judiciary anymore. You don't have a free press anymore. You have a very active press, but it's one that's absolutely controlled by Fidesz and the government of under Orban. You don't have any sort of separation of powers. You don't have the system of checks and balances that is critical to a functioning liberal democratic society. That exists all over the West. There's kind of a movement towards that. In Canada, it's much more subtle. I mean, we are still one of the best liberal democracies going right now, but there are attitudinal shifts that you need to pay attention to. As a matter of fact, I was just reading Andrew Coyne this morning in the Globe and Mail, who was just talking about the threat of the movement north of the 49th parallel of what is now being referred to as NatCon, or national conservatism, as opposed to free conservatism south of the border. A shift, an attitudinal shift in what conservatism really, really means. And the inherent populist, almost anti-constitutional, pro-autocratic or pro-authoritarian impulse that kind of runs through the body politic of that segment of the population is beginning to show its face even here. And one doesn't need to point to obvious, little blips or moments like the trucker convoy and what that might have disclosed, not so much about the participants in the convoy itself, but rather the broader population that is rather sympathetic to what maybe that convoy was really all about.
This is kind of a scary treatise that you put forward, and very concerning about the future of our democracies. We're going to take a break for some messages and come back and ask our guest, how did this all happen and where does he think it's going? Stay with us, everyone. We'll be back in just 2 minutes. Welcome back, everyone, to the Brian Crombie Radio Hour on Saga 960. We're talking about Canada's constitution and liberal democracy and constitutional democracies around the world that Peter Biro believes are at stress right now. Let me tell you, my guest is one of those really impressive individuals that exist in this world. He's got an incredible educational background. He's got a BA in political science from the University of Guelph, a master's in political science from McMaster University, a doctorate in studies in political theory from the University of Toronto, and then a law degree from McGill University. And he's had some interesting experiences. Right now, he is a senior fellow at Massey College. He was an associate at the University of British Columbia Center for Constitutional Law and Legal Studies. He was present at the Council for Hope, the Jane Goodall Legacy Foundation, the advisory committee of JIS Toronto, a founder of Section 1, the Education for Heroic Citizenship, University of Toronto Community Radio Public Affairs commentator, the chair emeritus at the Jane Goodall Institute Global, the chief executive officer of Newcon Optic, which got an award of Canada's Best Managed Companies, the advisory board chair of AVIL, the chair of the Jane Goodall Institute, the director of the board of education for the Jane Goodall Institute, a partner at a law firm where Folds, on the governor of the University of Haifa, president of the Friends of Haifa, a partner at Goodman & Carr, and a director of the board of directors for the West Toronto Support Services. So
let me just
involvement, academic involvement, business involvement, you've done it all.
Well, yeah, let me just make one correction, because I don't, if that reads a lot like a George Santos CV. One correction there. I was all but dissertation at U of T, because I left halfway through my PhD to go and get 2 law degrees at McGill. But no, so I didn't get my PhD. I was halfway through my PhD and then decided that I needed to study law very urgently. So that's that correction.
Okay, well, I appreciate that. And the book that is all about this backsliding is called what?
It's called Constitutional Democracy Under Stress, A Time for Heroic Citizenship, and published by Mosaic Press.
Where could we find it?
It's published by Mosaic Press. You can find it on Amazon, at Indigo. You can find it anywhere online.
And we were just talking before the break about you seeing this movement away from a democracy in Canada as well. Tell me where and how you see it. You
well, let me explain what I mean, because we can talk about very specific, obvious manifestations in various parts of the world. In Canada, it's not so obvious. And what I wanted to stress about this is that it begins with an attitudinal shift. And the attitudinal shift is then, in some places in the United States, we see this as an obvious case in point, is then in a way weaponized by interests that may have agendas that aren't even consistent with the interests of the constituency they're purporting to represent. But let me tell you why attitude is the critical thing, and then we can look at some Canadian examples. The real problem begins with the willingness, unwitting in most cases, of citizens to allow practices to occur that are just inconsistent with liberal democracy, and not to be scandalized by them at all. The United States is obviously our easy sort of case study for this, right? Because you see, a former president who may well be a future president do and say things that are antagonistic to the fundamentals of American constitutional democracy, and yet they don't feel troubled, the slightest bit troubled by it. And there's just too many examples to mention. But the attack on an independent judiciary, the attack on the integrity of the courts, the refusal to abide by subpoenas issued by Congress, the refusal to allow Congress to play its oversight role. We saw this in the impeachment of Donald Trump, both impeachments and both so-called trials, which were not trials in any sense of the word, because ultimately the truth about the subject matter ostensibly was of no relevance whatsoever, either to the outcome or to the real agenda of the constituency, right? Truth itself falls by the wayside. And really a central theme in my work is the assault on truth, the war on truth, the evisceration of truth, which occurs both coming from the left and coming from the right, and takes a number of different forms and has a number of different purposes. It's very, very complex, but truth has been eviscerated in our political discourse. And what does that lead?
Is it coming in? Is truth eviscerated? That's a tough word. I apologize. In Canada as well?
Well, it's eviscerated everywhere. You can't, we live in a global village, okay, and we all read the same media, we all consume the same media more or less. Social media knows no boundaries, so we view the same entertainment. So we're involved in the same conversations. We wear the same jeans and the same clothing. So the answer is, it has to be. It would be impossible for there to be, unless there was an iron curtain, all right, so to speak, around Canada. We're not immune to any of this. So it is eviscerated. And what do I mean by that? Well, if truth doesn't really matter all that much, let's just take a look at what's going on in Ontario with Doug Ford right now. It may be a silly example, but it's an obvious one. A generation ago, everyone on the right, on the left, it doesn't really matter where you stood politically and what your partisan allegiances would have been scandalized, first of all, by a premier running in a campaign promising to preserve the green belt, all right, and promising to ensure that it's not going to be open for development. Number one, he turns around in 5 minutes and breaks that promise. And that was scandalous enough. He remained in office. He hasn't resigned. He hasn't been charged with anything. There was criticism, of course, but his popularity wasn't affected all that much. And then in the last few days, we have the Auditor General's report that tells us what we all already knew, which was that his own developer buddies, or those of a certain staffer, but one has to imagine that this is all part of Doug Ford's circle, got preferential treatment in the way in which certain plots of land, and we're talking about, hundreds, thousands of acres of land, would be made available for development. And we're not sufficiently scandalized by this. The problem in democratic backsliding broadly is not that bad people do bad things or that good people do bad things. That's not the problem. They always have and they always will. There will always be corruption. There will always be self-interest. People will always try to hold on to power by any means. The real problem is in the societal reaction to it. Not just the institutional reaction, but more broadly the societal reaction, because the institutional response is going to only be as good and as rigorous and robust as society's sort of demand. All right. I've just recently written an op-ed, which I haven't yet submitted, but effectively the title is, constitutions don't protect themselves. Only a democratic citizenry can do that. And the subtitle is, Don't Blink Lest You Miss the Age of Liberal Constitutionalism. The problem is that we tolerate these things. And that's why, for example, the long-standing Convention of Responsible Government, which among other practices required, resignation of key ministers, and in some cases in the entire government of the prime minister, when they were caught breaking certain rules, ethical rules or legal rules. That doesn't exist anymore. And the only reason it doesn't exist is because there's a tolerance for behavior that would otherwise be intolerable. Let's just look at the SNC-Lavalin scandal. To me, it was a real scandal. The prime minister, without any doubt, and his staff and senior ministers in two departments clearly sought to interfere in the prosecutorial discretion of the Attorney General. We don't need to get into the details for this purpose. It was clear that they broke a fundamental convention. All right. And it was determined, the ethics commissioner determined that had occurred. What was the result of all of that? Well, the result of it was that the Attorney General herself was the one who ended up getting sacked effectively, and being kicked out of caucus at the end of the day. And the government just continued on its merry way. That behavior isn't shocking. What's shocking is that the rest of us weren't all that fussed about it. That's the problem.
So how did it come to this? And, your Ontario and Canadian examples are interesting and I think appropriate. But the U.S. example in the Republican Party is the most obvious today. And
yes.
And I've spent, as you probably have, a lot of time. I went to school in the United States. I worked in the States. I go there on business on a regular basis. And my Republican friends that are supportive of Trump still astound me, because these are smart, educated, knowledgeable people involved in the Republican Party for a long period of time that used to be the party of law and order. And it's because they think Biden and the Democratic Party is worse. For some reason, they're forgiving of so many things that they would have stood up and loudly. My very first day at school in the United States, we stood up all together and did the Pledge of Allegiance. I didn't even know what it was, and they believe that, and they believe that, but they don't really believe it anymore. What happened? How did this
So,
happen?
yeah, you put your, yeah, I mean, that's exactly right. Well, a number of things have happened there. Okay. Let's first look at the obvious and just simply restate what you've just described. Your Republican friends are more fussed about policies and ideas and agendas that they don't like than they are about the underlying sort of political and constitutional norms, right? That's definitely the case. So the Republican Party is no longer the party, as you said, not only of law and order, it's no longer the party really of a political agenda other than the agenda of disrupting the system, such as it is, and of dethroning the liberal intelligentsia that they assume is responsible for everything that's occurred. Why has this happened? Why has this really? Is it just about identity politics? Is it just about hatred of the other, demonization of the other? It isn't, because demonization of the other is already itself a product of the weaponization of certain underlying concerns. I think if you really go back and look at the original causes of the backsliding, it's that liberal democracy has not done all that well in keeping its fundamental promises, its original promises. The middle class society is withering away and disappearing. The promise of prosperity for the majority is withering away, is falling away, is not being kept. There is something, I'm speaking as someone who has been on the, I don't want to say on the left, but certainly on the liberal, center left, my whole life ideologically, although I don't think that's terribly important. I mean, I make a massive, important distinction between a commitment to the fundamentals of liberal constitutionalism and where you may sit ideologically on policies or political inclinations. They've got nothing to do with each other. And I'm more interested in talking about the fundamentals than I am about, whether you're left or right or somewhere else or in the center. But it's clear, even as a liberal lefty, one would have to concede that liberal democracy has failed to keep its promises. You have an increasingly alienated and neglected significant population that is not reaping the benefits of the of the post-war liberal market economy. Simply not. It's not happening anymore.
You're saying these people would rather have an authoritarian in charge because they think that the economic situation would be better for them.
So the answer to that question, in short, is absolutely yes, but it's not, and that may be shocking. There's a very, very interesting. I don't want to sort of take too many sort of side trips here in this conversation, but there's a very interesting body of work in social psychology. Karen Stennett from Australia is sort of the leader in the field, who've talked about what she calls the authoritarian personality and the authoritarian strain. And she's concluded, along with Jonathan Haidt, that actually the comfort level that we have with authoritarianism is actually very, very inherent in human nature. So that that's a kind of a partial answer to your question, which is that the authoritarian sort of view of the world is not all that unappetizing to most people when they really think about it.
Liberal democracies really aren't that old from a historical standpoint.
They're not that old at all, and more fundamentally, they're not inevitable, they're not obvious, and they're most definitely not immortal. But they're hard. They're bloody hard work.
Francis Fukuyama said the end of history. Liberal
democracy. Yeah, and he recanted. He recanted that. And by the way, just on that point, the title "The End of History" did not mean the conclusion of history. He meant the purpose of history. He was talking teleologically, the ultimate, fullest expression of where history could take us. And you make a good point identifying him. He recanted much of what he was saying in that book, because he recognized that, in fact, liberal democracy was not proving itself either to be as resilient or as attractive to enough of the world population. And in fact, he was one of the first people to talk about democratic backsliding, using different nomenclature, but to identify it.
One of the issues that has bothered me the most in regards to our democracy in Canada has been what I thought would never be used, which is the notwithstanding clause. And understand your forthcoming book is on the notwithstanding clause. So you know what I'd like to do is take a break for some messages and come back and maybe ask you a little bit about the notwithstanding clause and about this forthcoming book, and whether you agree with me that this is really one of those things that I thought would never be done. It was sort of put into the original 1982 Constitution, but was never going to be used. And it seems like it's being used now all the time. We're going to take a break and be back in just 2 minutes. Stay with us, everybody. Welcome back, everyone, to the Brian Crombie Radio Hour on Saga 960. Our topic tonight is liberal democracy and is it at risk? And we've been chatting with Peter Biro, who is at Massey College, Jane Goodall Institute. He's a lawyer, he's an educator, he's a writer, very smart gentleman. And we've been talking about his prior book, which was really about backsliding of people's attitudes toward constitutions and liberal democracy. His forthcoming book is going to be about the notwithstanding clause. Peter, maybe we could talk a little bit about it, but maybe you could just give us a little bit of a history lesson to start with, if you could, about what it is, where it came from, and then do you agree with me that it's been, in Quebec, in Alberta, in Ontario, in the last year or year and a half, we've mentioned it a bunch of times, used it a few times, and threatened to use it a bunch of times. Something that I thought we would never do.
Yeah, absolutely. Well, look, it's in the Constitution, and my thesis is if it's there, it's going to be used. All right. If it's there, it's going to be used. There are those, there are different theories about, first of all, what its purpose is. Pierre Trudeau, had to hold his nose and allow it in order to get the charter entrenched, as part of the patriation package in 1982. The notwithstanding clause, first of all, for your listeners, just so they know what we're talking about, is Section 33 of the Canadian Charter of Rights and Freedoms. And essentially what it does, and there's actually debate about what it does and how it works. So even as I explain this, there may be disagreements. But ultimately, it allows a government that introduces legislation that might infringe certain rights and freedoms in the Charter, not all of them, but certain stipulated rights and freedoms in the Charter. It allows the government introducing that legislation to suspend the operation of the Charter, or at least of the rights protecting function of the Charter, in a provisional way, all right, to allow the legislation to operate, notwithstanding the fact that it infringes the Charter. That's why it's called the notwithstanding clause, right? There is a very, very interesting and rich, and my book, has some wonderful essays in it, expressing all sides of this. A very rich and important discussion, indeed debate in Canada, as to who should get the last word, who should have the last word on whether a right is infringed, or on whether a right's infringement it should be permissible in a given circumstance. Who should get the last word, the legislature or the courts? That's the question. And the idea of the notwithstanding clause, at least on the part of many of its proponents, is that it's consistent with democracy to let the elected legislatures, whether it's Parliament or the provincial legislatures, to let them have the final word in a democracy on those questions. There's another strain. I call that the liberal constitutionalist strain, to which I subscribe and for which I advocate. that says in a liberal democracy, there has to be a dialogue between the judiciary and the legislatures. There has to be what's called judicial review just because a majority, for argument's sake, and in our country, it doesn't even require majorities, just given our system of elections and represent, the first past the post system that we have and minority government. But to simplify it, in our view, majorities don't get to say, don't get the final say just because they are the majority. Majority rule can, and often does, and it hasn't throughout history, delivered terrible outcomes for populations, right? Majorities trench on the rights and interests of minorities. Majorities commit or are responsible for ratifying the commission of terrible atrocities. So majorities should have the first say, definitely, but there are times at which, when certain kinds of special interests that are reflected and defended and protected in the Charter, are threatened, are put at risk, courts have a role to play in determining whether the infringement or rights violation, if you will, can be justified or not, and what the consequence should be. The notwithstanding clause allows governments to say, well, to the courts, you don't have a role to play here. Now, you, in your introduction, you mentioned that you personally didn't think this was ever going to be used.
I didn't. I never thought it would be used. It was one of those things that was sort of a Pierre Trudeau, agreement to try to get the Constitution put in place, the Bill of Rights. But it was, I thought, one of those things you would never do, because it was going to be deemed so inappropriate to be obviously offside of a right. Because how can a right be a right if you can actually take it away? It's no longer a right. So it would have been, I thought, to Doug Ford or to the Premier of Alberta, the Premier of Quebec, that you use the notwithstanding clause, unbelievably embarrassing to be obviously infringing on someone's rights. But now it seemed to be.
Well, from the very first minute that it was enacted, the government of Quebec invoked it, and they applied it to the entire statute book of Quebec. And then they invoked it over and over again. And not only have they invoked it, but they've invoked it preemptively. In other words, one of the things that people thought, for example, Jean Chrétien would have been on all fours with what you've just said. There's something called the rare use. It's not so much a doctrine, but for argument's sake, I'll call it a rare use doctrine, which is it should be only used in the rarest of circumstances, in emergencies, in various. And that was sort of Jean Chrétien's position. And he was one of the, not so much the architects, but one of the key negotiators at the time. But one of the things that was definitely agreed on by everyone, even the proponents of the notwithstanding clause, was that it wouldn't be used preemptively. What do I mean by that? It wouldn't be used before a charter challenge was brought by some party saying this law or this proposed law infringes a right. And then it goes to the courts, and then the courts determine whether A, there is an infringement, and B, if there is an infringement, is it justified under Section 1? By the way, that's Section 1 of the Charter, which inspired the name of my think tank, Section 1. But the preemptive use doesn't even allow the courts to do their job, doesn't even allow parties to go to court and say, there's an infringement. Judge, what do you think about this? And government, how do you justify this under Section 1? The preemptive use says we can dispense with all of that. We're just going to say in advance, it applies. There won't be judicial review. Whether there's an infringement or not, we don't know. In case there's an infringement, this law applies, and it's not going to be struck down, and it's not even going to be reviewed by the courts. That's extraordinary. And in fact, that's my interest in the notwithstanding clause, which dates back all the way to 1982, is really very consistent with the broad set of preoccupations that animate Section 1 and the work we were talking about just before this break. Because in my view, and it's only my view, and there are other brilliant minds who disagree with me vehemently, and they're equally competent and qualified liberal Democrats. But in my view, liberal constitutionalism is not consistent with a notwithstanding clause, especially when you have a Section 1 in the Charter that actually allows a government to say, okay, maybe there is an infringement here, but this is how and why that infringement is justified in these cases. And there's a test called the Oakes test that was decided by the Supreme Court of Canada a few decades ago after the Charter came into force that sort of lays out the proportionality test and the other elements of the Section 1 test that allow a government to say there are circumstances in which an infringement is defensible and justifiable. And so because we have Section 1, I say there's no need for Section 33, but they're very, very interesting and even compelling arguments in favor of Section 33 or the notwithstanding clause. The fact is we've got it, and since we've got it, it's being used. So the fact that you and others are troubled or surprised by the fact that it's used because you thought it never would be is all well and good. My own view is a little more realpolitik. It's there. It's a tool in the toolbox, if you will, and it's going to be used, and it will be used in an unrestrained fashion and unwisely by, in many cases. And in other cases, it may be used more diligently and with greater, restraint.
Well, I'm not sure whether you'll agree with this analogy, but let me try it on you. I got into a really interesting argument with a friend of mine who's very involved in Israeli politics from Canada a week or two ago, and I was arguing against what Israel is trying to do with their constitutional
right,
which is effectively allowing, I think, and you may know more about this than I, but effectively allowing the Israeli parliament to override all of the decisions that the Supreme Court of Israel make. And I was talking about this as being an autocracy, it being terrible, and went on and on and on. And he says, you're completely inappropriate because the notwithstanding clause effectively means Canada has got a very similar situation. And I was shocked with that comment. I was very taken aback, and I had to stop and think about it to say all these things that I was disagreeing with and thinking were terrible in Israel, in regards, not in Israel generally, but in regards to this bill that Netanyahu has put forward, that we've got in Canada already because of the notwithstanding clause. Is that
right?
That analogy, does that analogy make any sense?
So it makes sense. I wouldn't agree with it, but it makes sense. First of all, Netanyahu himself invoked the notwithstanding clause, Canada's constitutional experience, in defense of what he was doing. He was saying, look, other modern, liberal democracies have it too. First of all, just 2 points of clarification. The Israeli judicial reform, which is actually quite comprehensive and scary as heck, the first tranche of it that you've described, it doesn't allow the Knesset to override everything that the Supreme Court does. It refers only to decisions where the court strikes down as being unreasonable. It's called the doctrine of reasonability or reasonableness doctrine. The reasonableness doctrine is when the Supreme Court strikes down a law of the Knesset, of the Israeli parliament. In those circumstances, the parliament can override or disregard that law. That's a bad thing. Yes, it is analogous in certain ways to the notwithstanding clause, but the notwithstanding clause is circumscribed very, very precisely. First of all, there are only certain kinds of rights and freedoms that are subject to the notwithstanding clause. The notwithstanding clause has a sunset clause in it. It's got a time limit. I mean, there's a reconsideration that the Parliament of Canada or the legislatures must go through, every 5 years, etc. So it's not nearly as broad as what the Israeli Parliament is contemplating. But the analogy is not it's not an unreasonable one. There are similar kinds of concerns that should be shared in both cases. Now, Israel, unlike Canada, does not have a written constitution. It's got what's called the basic law, which are basically two critically important pieces of legislation that have been interpreted in a particular way. But they don't have constitutional status. But be that as it may, what's going on in Israel is of deep concern in terms of democratic backsliding, the conversation we were having earlier. And yes, it is also relevant or germane to our conversation about the notwithstanding clause in the sense that the current judicial reform that has already just been voted on a couple of weeks ago involves Parliament overriding the decision of the Supreme Court in certain, types of cases. That's of deep concern, absolutely. But it raises the legitimate and very interesting question again, who should, in a liberal democracy, have the last word on these questions? And what's the role of an independent judiciary?
Well, I'm going to go to that. And what we should do from here, just after we take a break for some final messages. We're going to be back with Peter Biro in 2 minutes with some concluding comments. Stay with us, everyone. Back in 2. Welcome back, everyone, to the Brian Crombie Radio Hour on Saga 960. I'm having a really enjoyable conversation, a little scary as well, with Peter Biro, who is a Massey College individual, a Jane Goodall Institute, a lawyer, an educator, a writer. He's got an incredible pedigree. He's written a book that is about the backsliding of democracy, and he's about to come out with a book on the notwithstanding clause. Peter, tell us, if you could, just before I ask you a final question, what the title of these 2 books are and where people can get them if they're interested in reading some of your incredibly interesting work.
Oh, thank you for that opportunity. The first one's called Constitutional Democracy Under Stress, A Time for Heroic Citizenship. It's available online everywhere. It's out from Mosaic Press, and you can get it online. The one that's forthcoming from McGill Queen's University Press, you can't order it yet, but it will be out in the winter-spring catalog. It's called The Notwithstanding Clause in the Canadian Charter, Rights, Reforms, and Controversies, and I hope that people will take a look at it.
Peter, I'm a business guy, and I haven't studied corporate law, but I end up sort of getting involved in corporate law on a fairly regular basis. And on this topic, when I'm drafting a shareholders agreement or I'm taking a look at corporate law, there's 2 things that I think might be good practices to apply in your situation. One is minority protection rights, and when I think about minority protection rights, those are rights that we know the majority may want to at some point in time infringe. And so we put them in the shareholders agreement. So there's no way that the majority can ever infringe upon it. These are accepted as, it's a minority, and the majority might want something different, but it's a minority protection right. So it's a right that can never, ever, ever be controverted. And so I kind of think rights in constitutions should sort of be like that. And then the second thing is, in a lot of major decisions, you need a supermajority. 50.1% is not enough. In minor decisions, 50.1% is enough. And on some decisions, you can't just do it at the board of directors or at the annual meeting. You got to go and do a shareholder vote. You got to do a proxy and go out to everybody. Now, when I think about how close Quebec separation came, when I think about how close Brexit was, shouldn't major decisions need a supermajority of 66.6%? So when you think about corporate law, maybe we've done corporate law better than constitutional law.
You've just made some fantastic and very on point, observations. I agree entirely with your sensibility and with your insights there. Start with minority rights. That's precisely the issue that is engaged by Bills 21 and 96 in Quebec. And we don't have time now to get into those, but that's exactly what's at issue there. Minority rights are at issue, and they're on the chopping block with the invocation in Quebec of both the Canadian Charters notwithstanding clause and also the Quebec Charters notwithstanding clause. Both notwithstanding clauses were invoked there. So, there are those, including myself, who argue that Quebec is moving away from being a liberal constitutional democracy because of those two bills and because of the impact they have on minority rights that you've just described. On your second point, which I also agree with, you talk about supermajorities for important decisions. Look, the amending formula for Canada's constitution requires a kind of supermajority of provinces and population, right, in order to make amendments or changes to the constitution. I'm not overly fussed on what a supermajority should look like, whether it's 66 or 55 or 70. What I do agree with you on is that there needs to be a meaningful consensus, whatever that means. It doesn't mean unanimity, but there should be a broad consensus, however we end up defining that, when these kind of fundamental decisions are made and when interests such as the interests of minorities are sacrificed for some other purpose. Again, that would need to be justified. And under Section 1, the argument can be made that there's a process that allows you to either justify or fail to meet the threshold necessary for those types of infringements. So I'll just say that I agree broadly with your observations on both those points. But the issue is consensus, really. That's what's important, not the formal structures and the formal manifestations of this. And this is why, going back to the point we began with, it's about attitudes, right? And it's ultimately about a societal, what I call epistemic foundation. Do we have a shared epistemic foundation? Meaning, do we have a societal consensus on broad, important questions of fact, of things that we know? And the answer, I think, is that's breaking down. No, we do not. No, we do not any longer have that. And that makes it impossible for us to agree to generate consensus on really important problems, problem identification and solution identification as a society. It doesn't matter whether we're talking about climate change or we're talking about pandemics, or any, emergency response or anything. If you can't generate consensus, and for a variety of reasons, and this goes back to the point about the assault on truth, then you can't operate effectively, efficiently, and fairly. And yes, I like your analogy about with corporate law and minority rights. Incidentally, Ralph Nader begins with that, right? And not so much corporate law, but with the world of business and consumerism, right? Way back in the 50s and in the 60s. And that then translates into, so we go from shareholder and consumer rights to citizens' rights, right? And they're analogous.
Well, I think you raise a really important issue that we're not going to have time to talk about, which is how do we actually drive and achieve consensus? And that's probably the most important issue that we've got right now in our societies, because we're all stuck in these different echo chambers and we don't talk to one another. And so it's impossible to have any kind of consensus if you don't even listen to other people's points of view. Anyway, that's a topic for another day. Peter Biro, thank you so much. This has been a really interesting conversation.
Thank you so much for having me. I'm really grateful for the opportunity to share these thoughts.
I remind you, everybody, I'm on every Monday through Friday at 6 o'clock on 960 AM. You can stream me online from anywhere in the world at www.saga960am.ca. All my podcasts and videocasts are available on my website, briancrombie.com. Peter Biro, thanks so much. Good night, everybody.